Hi, my name is Christopher Oldie. I am an attorney with Legal Services of the Hudson Valley. Today I'm here to speak with you about tips for going to court on your housing case or your eviction case. So here are some practicalities and key pitfalls to avoid as it pertains to going to court for your eviction matter. First things first, stay calm. This is a very stressful time for you. I understand that. Losing your home is always a stressful time. But the more excited you get, the harder it is to make informed and logical decisions. If you can, try and stay as calm as possible. The court system and the laws are there to help you if you ask the right questions. So the first thing you need to do is stay calm. The other thing that you need to do is don't be late to your court appearance. If you're late to the court appearance, they could have the proceeding without you there, and what could happen is you could have a default judgment attached to you, which means you won't have the ability to try and defend your case if you don't show up. So, how to make sure that you're not late? Make sure you have childcare in place. Make sure that you know how to get to the court. Make sure you know where to park. If you are not driving there and you have to take public transportation, make sure you know what bus to take, how long it's going to take. If you have to take a cab, is it busy? Is there traffic? If possible, I would suggest doing a dry run before you go to court. Make sure you know how to get there and where to go so you won't be late. Note that some courts do not allow you to have your cell phone, so I would suggest not even bringing it if you don't need to, but be aware that a court may take your cell phone, as some cell phones are not permitted in to the courtroom. And I would also suggest to make sure that you dress in appropriate attire. You can bring a significant other with you, a spouse, a friend, but you are the only person that's going to be able to stand up before the judge if you are the one that is listed on the court documents. You can bring someone with you if you need some support system there, but make sure you are the person that's there that's going to stand up before the judge to talk about your case. You can certainly ask questions. The court personnel, the court officers, they are there to assist you, especially if you are nervous. So make sure you ask questions in a respectful manner. Find the clerk, find the court officer, ask any questions that you may have about the proceeding or about what's going to happen if it's unfamiliar to you. There are lots of different courtrooms in different locations. So there could be a criminal courtroom, there could be a civil courtroom, there could be a consumer courtroom. Make sure you know that you're in the landlord-tenant section, and if you have questions, make sure you ask them. As I said earlier, you might not be able to have your cell phone, so I would suggest bringing a pen or a pencil, as well as a piece of paper or a pad of paper, to be able to take notes. If you were expecting to take notes on your cell phone and you no longer have your cell phone, then you don't have anything to write your questions down with or keep track of what's going on. So bring a piece of paper and a pencil with you. So when you get to the courthouse, some of the things that you can expect are as follows. You will have to go through a security line, so make sure you do not have any contraband with you. If there are mask requirements or vaccination requirements, make sure you check in with the court beforehand to make sure that you're able to get into the courthouse. When you finally find that courtroom that pertains to your specific case, check in with the clerk or check in with the court officer to make sure that there's nothing else that you need to do. If they check you in and they say you need to wait, then just sit and wait. Again, with different COVID protocols, they may ask you to stand outside or in a different part of the courthouse, but anyway, you just need to find out what is required of you. When you're in the courtroom, you may hear someone call your name, and it may be someone that you're not sure who they are. It could be the attorney for the landlord. Many landlords' attorneys will try and seek you out, you as the tenant, beforehand to talk about your case. They may want to figure out ways to settle the case before the judge calls you to the front of the courtroom to talk about the case. If you feel nervous about speaking with the landlord's attorney, you can decline to speak with him or her and just wait before you get to the judge. If there are things you want to discuss with the landlord's attorney, you can do that. Just make sure that you are treating the landlord's attorney respectfully and that they're treating you respectfully as well. And don't enter into any agreements that you do not believe that you're going to be able to follow or that you don't understand. Because this is a civil matter, not a criminal matter, you do not have automatic right to counsel. So that's why the landlord may be speaking with you even if you don't have an attorney. If you are desirous of getting counsel and you have a legal service agency in your area that might be able to represent you, you can let the attorney know that you're going to try and seek counsel, and you similarly can ask the court that you need more time to seek counsel. But again, it's not guaranteed because it's not a criminal matter. You may have to wait a while for your case to be called. Be aware of that. Each court is different. Sometimes courts have criminal calendars first, and then they have the landlord-tenant calendar. But at some point, your case is going to be called, and you and the landlord or the landlord's attorney, or both, will show up before the court to discuss the matter. So here are some tips, litigation tips, for preparing your case on your own. You want to make sure that you bring all your documents with you. Everything that pertains to your landlord-tenant case, you want to bring with you. So all copies of your leases, copies of your canceled checks, any type of document that's going to be helpful to you to be able to show the judge is important for you to bring. Also, if you have any witnesses that had witnessed any of the behavior of the landlord or witnessed perhaps any of the damage to the property, any of the habitability concerns that you think are going to aid in the defense of your case, bring those witnesses with you and make sure they are fully prepared to be able to speak with the court about your case. Note that if you have documents that you want the judge to see, you will likely not be able to just hand them over to the judge. You need to give them first to the court officer, and then the court officer will then give them over to the judge. You should hand everything over in a respectful manner and make sure that the court officer is aware that you would like the judge to review these documents at the appropriate time. Make sure that any type of photograph that you have is off of your phone and actually printed out. The judge is likely not going to take your phone and scroll through it and look through the pictures. Make sure you have the opportunity to print out those pictures to be able to show to the judge, because number one, the court may not allow you to bring your cell phone in, and two, the judge is not going to take your cell phone to review it. Make sure you have physical copies of pictures of anything that you want to show the court, whether that's mold or damage because of leaks, etc. You want to be able to have those pictures printed out. Now, when you finally get up to see the judge, there are different things that can happen. Again, you might want to ask for an adjournment, so that's more time. You want to ask for another court date. Perhaps you're trying to get legal counsel and you're asking the court for that. You may have issues with service. That means that you actually were not given court papers. Maybe for some reason your neighbor told you that you were in court the next day and you showed up, but you never actually got physical court documents handed over to you. They never came in the mail. They never were attached to your door. If that's the case, you may tell the judge, listen, I was not served in this matter and I should not be there. And that might be a grounds for dismissal of the action. You should also note that you might be a witness in your own case. The landlord may call you to the stand. If that happens, answer the questions truthfully and in a respectful manner. Here's some other tips for how to really behave in the courtroom. So you want to make sure that you tell and treat the judge with respect. So when you address the judge, you say, Your Honor. You do not want to address the landlord or the landlord's attorney. You do not want to address them directly. Even if they are just a few feet to your left or to your right, you want to address the judge. If you have something to say specifically to the landlord or to the landlord's counsel, you say to the judge, this is what I need to tell you about the landlord. This is what I need to tell you about the landlord's attorney. This is the conversations that I've had. This is what I don't understand. Direct it to the judge, because the judge is the one that's going to want to figure out how to make that proceeding and that case go forward. Don't raise your voice. Even if the landlord says something that upsets you, behave in a respectful manner. The judge will respect you then. If you're confused, again, feel free to ask questions. Ask the judge questions, especially if there are some legal words or phrases that you don't understand that are being said. Make sure that you stop, maybe write it down, and make sure you understand it before you go on to the next part of the case. So if you do have some sort of hearing with the judge and with opposing counsel or with the landlord, a few different things can happen. So it could be an adjournment. Maybe you didn't get through to everything, or maybe the judge wants more time, or maybe the judge is going to allow you the opportunity to seek counsel. If that happens, then the case will be put on for another date. Could be the next day, it could be the next week, it could be the next month. It will depend on why you need the adjournment. If for some reason you agree with how much is owed, if you owe rental arrears, you could agree to a money judgment. And a money judgment is just that. It's an amount of money that you agree to pay off in a certain amount of time. Be advised that if you do not pay off that money in the requisite period of time, you can then be evicted. So if you are going to agree to a judgment, make sure that you're able to pay off that judgment, because if not, you could be then subject to eviction. Another kind of judgment is a judgment of possession. That is when the judgment states that the landlord will get possession of the property after a certain period of time. If you are still living in the premises when that period of time comes for the landlord to get the possession back, you can be evicted. You also may be subject to a money judgment and a judgment of possession. That means that you owe a specific amount of arrears in rent, and you also have to be out of the premises by a certain date. If neither of those things happen at the time that they're supposed to, you can be subject to your doors getting locked by the marshal or the sheriff. You may end up settling the case via a stipulation. That's a written document that you sign with the landlord or the landlord's attorney that you're going to do specific things and the landlord's going to do specific things to be able to finalize this case. If you do not understand what is in that stipulation, I would urge you not to sign it. However, if you are comfortable with what's on those pieces of paper, then feel free to do so, but do not enter into a stipulation if you're not going to be able to fulfill the requirements of the stipulation. That is a one-way ticket to find yourself with your doors locked and your eviction going forward. The case could be dismissed or withdrawn based on the arguments that you put forth before the judge, or they could schedule another case, another date for a trial or a continuation of the hearing. So many different things could happen at that first court appearance. It might depend how crowded the court is. It might depend on how many cases are on the calendar. It might depend on what the landlord wants to do in the case, and it might depend on what you need to do in the case. But what you need to remember is to stay calm, be respectful, ask questions, and certainly don't enter into any sort of agreement where you do not believe that you'll be able to fulfill the requirements thereof. This is a very stressful time for everyone, and we at Legal Services the Hudson Valley and all legal service agencies understand that. We are constantly working with the court system to make sure that you as tenants and you as homeowners are respected, and we wish you the best of luck going forward. Thank you.